Hearing the appeal, Tony McCue regarding to Andrew McCue against Glasgow City Council.
Yes, Mr. Day. My Lords, the issues which fall to be determined in this appeal are, firstly, whether the Court of Session erred in law in concluding the respondent was entitled to reject the appellant's disability-related expenditure, which I will refer to as DRE for shorthand, if I may. And second, whether the appellant's 8 grounds of appeal are well-founded. My Lords, the 8 grounds of appeal are set out in the permission to appeal application granted by this court on the 15th of February 2022. And that can be found in electronic folder pages 29 to 32. For my submission this morning, I would propose to group the appellant's grounds of appeal under 3 chapters. First, the misapplication or reading down of the Equality Act 2010, and that comprises of grounds of appeal 1 to 5. Second, the error in law in not finding that the respondent's charging policy and provision criterion or practice towards DRE was discriminatory and unlawful, which comprises of grounds 6 and 7. And finally, the error in law in holding that the petition was not amenable to judicial review, which comprises of grounds 8. Now, before I turn to the appellant's legal propositions supporting those grounds of appeal and the respondent's submissions thereto, I would propose to briefly highlight the respondent's charging policy and its provision criterion or practice, which I shall refer to as PCP for brevity, if I may, towards DRE. Apologies for the abbreviations, but I think it may be helpful. Now, this is, of course, the primary context of the appeal. The aspect of the respondent's charging policy challenged in this appeal is to be found in section 12 of its policy document, which is EF page 198. And that's under the heading, Income to be Disregarded. And my Lords, it's fairly brief. It says...
Sorry, which document? Remind me, which document is this?
This is in the appendix, my Lord President.
This is the COSLA guidance, is it?
No, this is the respondent's charging policy. It's in the appendix, in the core volume,
yeah,
which is page 198. Oh, sorry, 198.
Yes. And which document is it in the appendix?
So this is in the core volume, and this is the charging policy of the respondent.
It starts at 190.
Indeed.
So, yes.
I see.
The reason I take the quote to page 198 is that is the specific part of the policy that the appeal is concerned with. And as I had noted, it's fairly brief. If we go down to sort of the middle of 12.2, where it says consideration. So consideration will be given to representations to take into account other specific costs of living, e.g. in relation to disability-related expenditure. Now, the respondent then sets out its PCP, so its practice in relation to that policy, in answer 9 of its written pleadings. And answer 9 can be found at EF page 142, which again is in the core volume, and at tab B of that page. The PCP as stated in the pleadings, was to exclude DRE under 3 grounds.
Sorry, page 142.
142, my lord.
You're taking us to... Where's the statement of policy?
So, if one looks at EF page 142,
I'm sorry, but just before I've been trying to get to grips with page 198. On this page, is it simply the bullet point that says that consideration will be given to representations to take into account other specific costs of living, e.g. in relation to disability-related expenditure? Is that all interested in?
yes, my lord.
Right, okay.
Yes.
I mean, it might be said that's not exactly a policy. That's just saying representations may be made. It doesn't say what test will be applied.
Indeed, my lord, which is why I wanted to take my lords to the position that the respondent has set out in the pleadings in terms of what its practice is in relation to the charging policy, which, coming back to...
I'm so sorry, just on that. So far as the council was concerned, I don't think it was required to have a policy, was it? So under the 1968 Act. The 1968 Act gave it a discretion whether to make charges for services which were being provided by the council, and set limits on that discretion in terms of the reasonable practicability of payment. Is that right? So,
my Lord Sales is absolutely right. That is the position. Of course, what the respondent has then done is it has adopted a policy which, as we shall see later this morning, also says that it adheres to the Convention of Scottish Local Authorities as well in terms of their approach. I hope that answers at that point. Sorry, coming back to my Lord Lloyd Jones's issue in terms of
142, we see the PCP, you say?
Yes, my Lord.
And can you help me on that? Does that amounts to the practice, does it?
Yes, my Lord. So if we look at EF page 142...
PCP is petitioner's charging policy. Sorry, I missed. Is that what you said? Sorry, the acronym.
Provision, criterion, or practice.
Is this a term of art in the context of the Equality Act?
It is indeed, my Lord.
Could you give it to us again then?
Provision, criterion, or practice. And I'll take my Lords shortly to the relevant provisions in the 2010 Act where this term of art appears.
But 142, this is simply Council's averment as to the reasons why the Respondent Council rejected particular items that had been claimed as DRE by the petitioner, I think.
Indeed, but what the appellant would contend with respect is that was the practice, that was the approach of the respondent in relation to DRE.
Are you meaning a general practice, or are you meaning that for the purposes of the Equality Act, what we're concerned with is what happened to the petitioner, how he was treated?
My Lord, my understanding is that this is the general approach to the charging policy. This is how the respondent operates its charging policy in relation to DRE.
Well, where do we find? We don't find that in this pleading. I mean, obviously, Mr. McCue's needs are individual to him, and I suppose, I mean, this, I'm having a bit of difficulty following the argument at the moment. I mean, we're told that the council rejected claimed items on 3 grounds. Some of them were rejected because they didn't relate to disability.
Yes.
Some were rejected because, although they did relate to disability, the cost was covered by a benefit.
Yes.
And I don't think you're taking any issue with either of those two, are you?
No, the appellant is taking issue.
And then thirdly, we're told items were rejected because they weren't necessary to meet the assessed need, but were discretionary.
Yes.
Right. So is that the one you're taking issue with?
That's the primary one, but as I'll develop, if I can, the appellant is taking issue with the whole approach in terms of the.
Oh, so I misheard, I think, how you responded to my Lord Lord Reid. You are challenging the first two.
Yes, my lord. Yes.
Right. Sorry,
Yes.
I thought you said you weren't.
So I mean, are you saying that the council aren't entitled to reject claims for disability-related expenditure on the ground that they don't relate to disability? Or are you saying that a wrong decision was made in relation to on particular facts?
My lord, what I'm saying is that the way that the respondent considers things that arise out of disability is flawed, because they take a very narrow approach in terms of what that is. For example, something that has to arise from the physicality of a disability. To give an example, if I may, so the idea that you've got an extra cost to, for example, attend a social event or some place, and you have to bring a carer with you because you're not able to go on your own because of learning disabilities. The extra cost, for example, of the carer, the appellant would contend is a disability-related expenditure, whereas the respondent takes a very narrow view of disability. I hope that helps. I mean, I'm going to hopefully develop this position.
Very well.
I'm sorry, in relation to the second one then, as I understand it, if the appellant receives a benefit, some of those benefits aren't included in his income, in the calculation of his income.
Yes.
And if those benefits then do meet a cost in question, and those costs were also then deducted, he would be recovering twice over, wouldn't he?
No, my lord. So, for example, and I'll take the court to the specific provision. So, for example, in terms of mobility, so disability living allowance mobility component is specifically designed to enable somebody who's disabled to lease a vehicle in order to be able to get from A to B. And by way of social security law, that's specifically excluded from somebody's income. I think what the appellant would contend is that social security benefits are designed to enable, whether it's an able-bodied or a disabled person, to live with a minimum amount of income. And disability benefits come along because the UK Parliament has recognised that you have additional costs to live on as a disabled person. And perhaps the way for me to put this, kind of cut into the heart of it, is what the respondent does is it comes along and takes some of those benefits to pay for some of the services it provides for. And the difficulty with that is that the disabled person has got that extra money because the UK Parliament has recognised that they have additional costs because of their disability. And that's then taken away by the local authority. And so you end up, this is where the disadvantage comes from, you end up disadvantaged because you've got less than you would have otherwise had.
I don't understand this. If you, as you say, disability benefit is designed to compensate for additional costs arising as a result of a disability. But if you're already receiving a benefit to cover a particular additional cost, then you don't require a disability benefit on top of that to cover the same cost. This is the point Lord Stephen made, it would be double recovery.
But, my Lord President, the appellant's position is that there is no double payment as such because under the 1968 Act, the local authority has obligations to provide community care services. And those are provided in this particular case for 30 hours a week. So 9 to 3, Monday to Friday. And the position of the appellant is that the appellant has the rest of the week. So the majority of that period of time, he is incurring additional living expenditure. So, for example, if he wants to be able to go somewhere of an evening for social activities, it's more expensive for him given his disability, or at the weekend. Now, in my submission, disability benefits are there to because they recognise that reality of life.
Yeah. Obviously, up to a point. If the appellant wants to go on a holiday to Australia, I presume you're not arguing that benefit would have to be paid to meet the need of a carer travelling with them to Australia for a month's holiday.
Absolutely correct, my Lord, because it has to be. So the premise is it's to enable somebody who's disabled to have an independent life as if they didn't have a disability, and that has to be within the confines of being reasonable. So anything that was perhaps more egregious clearly would not be something that would be relevant. And indeed, I would fully accept that a local authority could reject such additional costs as not being reasonable.
So, it rather sounds as though you're taking issue, as I understand it, with this approach, all three arms of it, as being, as I understand it, incompatible with the duties incumbent on the authority under the Equality Act.
Yes, my Lord.
Okay.
My Lord, I'll try and move on because we've covered some issues I think which have been extremely valuable. But just to sort of again set the context briefly, if I can. So the extra costs that Mr. McCue have, and in my respectful submission, these are not unreasonable things that a person would do. So he attends specialist clubs as his only form of social activity at the weekends and in the evening. So there's extra costs of diesel being driven there. He can't walk on his own because of his learning. He has to be accompanied by somebody. He has extra costs for bedding because of a skin condition related to his disability. If he goes to events, he has to bring a support worker. If there's not a family member that's available. And he's not able to do washing and ironing himself because of the nature of his disability.
Under Section 5 of the 1968 Act, I think that the Secretary of State has the ability to give guidance as to the exercise of the discretion. Has any guidance been given in Scotland? It certainly has been in England and Wales, but has it been given in Scotland?
Not to my understanding, my Lord. The only national guidance in Scotland, which is not the same as the statutory guidance my Lord Philip Stevens is referring to, is the COSLA guidance.
And that isn't statutory guidance?
That's not statutory guidance. Yeah. And perhaps that is
But for those who aren't initiated to the mysteries, COSLA is a convention of Scottish local authorities.
Yes, my lord.
So it's a sort of association of local authorities.
Yes, my lord. And I think, just coming back to my Lord Stephen's point, perhaps where some of the mischief arises, where it doesn't arise, in my respectful submission, in England or Wales or Northern Ireland, because of that statutory guidance in England. My lords, in my submission...
Does the statutory guidance in England have a requirement of necessary to meet the assessed needs?
Yes,
it does.
I'm not sure, my lord, if this...
does it have guidance about discretionary spending, which was not necessary to meet assessed needs?
I'm not sure of the position.
Yeah, okay.
My lord.
Okay.
I could come back to that if that would help. So the appellant's position is that the second division had erred in its approach to DRE as only being relevant if it was essential or non-discretionary expenditure. And the essential expenditure reason...
Sorry for coming back to you. What is meant by assessed need as opposed to disability? They represented discretionary spending, not necessary to meet disability, or is it assessed need? Which should it be?
Well, the appellant's position, my lord, is that the 1968 Act is a separate legal framework in relation to assessing need in terms of Section 12 for community care services. And I think the difficulty that we have in this particular case is that we then have the duties that are in the 2010 Act being conflated with the 1968 Act. And I would submit that they're two separate things. One is to do with assessing the need in relation to what the local authority is going to provide. But in relation to the 2010 Act, in terms of not having unfavourable treatment for somebody who's disabled or not creating a substantial disadvantage, I would respectfully submit that requires the local authority to look at the position of the person in the round in terms of their life on a 24/7 basis. Because I see no curtailment in the 2010 Act in relation to that. Just for the sake of clarity, the second division's position with respect to DRE having to be essential expenditure is at paragraph 51 of the Lord Justice Clerk's opinion. And just to note that that's EF page 107. The reference to non-discretionary expenditure was referred to by the Lord Pentland at EF page 91 in his interlocutory refusing permission to appeal. My Lords, what the appellant says is this, that there's no statutory basis for the second division's approach to DRE, and that such an approach misapplies and reads down the extent and application of the Equality Act 2010 for disabled persons. The Equality Act is, of course, an act of the UK Parliament. It extends across the United Kingdom, and I would respectfully submit that it cannot be correct for it to have a different application in England and Wales and Northern Ireland to Scotland. My Lords, I'd said that I was grouping my submissions in terms of legal propositions into 3 short chapters. If I can turn to the first, which is the misapplication or reading down of the 2010 Act, and if I can just take the court very briefly to the statutory framework which is applicable, just to provide that context, if I may. I do address this area in some detail in the appellant's written case at EF pages 59 to 65, and I don't intend to go over all of that, but more to kind of focus and zoom in if I can.
Can I just before we do that, I appreciate you're very familiar with this legislation. Not all of us are. Can I just check that I've got at least the hang of the structure here? The concept of assessed needs seems to appear in section 12A of the 1968 Act.
Yes, my lord.
At page 358, and so this is a provision which imposes a duty on the local authority to assess the needs of a person for community care services.
Yes, my lord.
So that's the starting point. And then under section 87, which is on page 362, the local authority are entitled to...
I think it's 363, my lord, for Scotland.
Oh, 363. Oh, you're quite right. Beg your pardon. 363 for Scotland. So, a local authority providing a care and support services may recover such charge for the services as they consider reasonable. That's a starting point.
Yes.
But under 1A, if a person satisfies the authority providing the service that his means are insufficient for it to be reasonably practicable for him to pay for the service, the amount which he would otherwise be obliged to pay for it, the authority shall not require him to pay more for it than it appears to them that it is practicable for him to pay. So is that the statutory foundation for the assessment of DRE?
No, that's the statutory framework for the provision of community care services that the local authority think are necessary to provide.
And also for the charging for those services.
Yes, indeed. Yes, indeed.
Yeah.
Absolutely. So, for the charging of the services of community care, which the local authority decide is what is necessary to provide the minimum community care, non-residential care that a disabled person requires.
Yep.
And what the appellant says, that's all fine, but the 2010 Act comes along quite separately and is much wider. Because
well, before we get to the 2010 Act, if you just bear with me for a moment, DRE isn't a concept, is it, that arises under the 1968 Act?
It's not.
No. So far as the 1968 Act is concerned, am I right in thinking that the statutory framework that it provides for the charging for services and for making allowance for limited means on the part of a recipient of the services is section 87(1)(a)?
Yes, my lord.
Okay. So under that provision, the duty of the local authority is not to require a recipient to pay more for the services than it appears to them that it's practicable for him to pay. And he has to satisfy them that his means are insufficient for it to be reasonably practicable for him to pay the cost that would otherwise be payable.
Yes, my lord.
Right.
Yes.
Okay.
And just to pursue that, on my understanding, it's in the context of subsection 1A that the concept of DRE, which isn't a statutory concept so far as I can see, comes in, that it's It's, if you like, the outcome of a practical test that a local authority will apply to test whether it is practicable for someone to make a contribution to the services that they provide.
Yes, my lord. But what I would add to that, if I may, is that only arises because of the 2010 Act, because it's only the 2010 Act that creates separate duties in relation to ensuring that a disabled person is not unfairly treated or suffers a substantial disadvantage.
Well, is that right? On my understanding so far, in crude terms, if someone is having to pay money themselves to meet some, let's say, some pressing need associated with their disability, so that money is necessarily dedicated to such a pressing need,
yes,
that will be a basis on which the authority ought to conclude that it's not practicable for him to have recourse to that money to pay, to make a contribution to the services that they're providing.
I see my lord's point, and that's absolutely correct.
Right.
I suppose what I'm trying to develop is that there's then separate duties that come from the 2010 Act.
I suppose the question being posed is, where does DRE actually come from?
Yes.
Are you saying it didn't happen prior to equalities legislation?
That's a very critical point, my Lord Burrows, because I think my Lord Sales has got me thinking that even going back to the 68 Act, the subsection 1A allows for somebody to make that argument, which is that I have this pressing requirement in my personal life that it's not reasonably practical for me. Now,
even before 1A, subsection 1 was enacted in 1968,
yes,
and it limits the recovery of charges to what the local authority consider reasonable.
Indeed, my lord.
Now, 1A, we can't see from the print of it that we have in front of us when that was actually introduced. Do you happen to know when 1A was introduced into the 1968 Act?
16. I think I'm looking at the footnote, my lord, which is italic 16, small 16, and that appears to be added by the Community Care and Health Scotland Act 2002. So that's the 1st of July 2002.
So that was 8 years before the Equality Act in that case.
Indeed. But I think, just coming back to my Lord Sale's point, I think that must be right, that the mechanism is there, and as my Lord President says, in section 87.1, it's got to be reasonable, as my Lord Sales says, in terms of subsection 1A, it's got to be practicable. But coming back to my Lord Burrow's point, did DRE exist in 1968? I don't. Sorry, it's been a very long journey, but I think the short answer is no, it didn't in my submission, and it was the 2010 Act, in my respectful submission, that created this kind of wider idea, and obviously cases going back to the House of Lords. I think I've mentioned in my written case, I think the Archibald case. So there's been a long journey from the Disability Discrimination Act 1995 to the 2010 Act, and this is, in my submission, where this idea of DRE and this more kind of, I suppose, a more liberal kind of approach.
I was just wondering whether that's correct, because in Cornwall, Mr. Justice Hickenbottom referred to guidance issued in 2004 from recollection, and wasn't he dealing with DRE?
Well, indeed, my Lord, but I think the point it's making is that one goes back. The 2010 Act incorporated the Disability Discrimination Act of 1995, and it was the 1995 Act that was the landmark sea change with respect to equality law and disabilities. So I think, to answer my Lord Stephen's point, that makes absolute sense in terms of Cornwall, because actually if it was 95 that this comes onto the scene in the UK.
Well, again, if I could just add my tuppence worth, I'm not at all sure that that is right as a matter of analysis. I mean, DRE is not a statutory defined term in any act, so far as I can see. If one goes back to Mr. Justice Hickenbottom's judgment in the Cornwall case, he is, as my Lord Stevens points out, actually directly addressing questions of DRE, and indeed you referred to that in your printed case, and he's doing so before the Equality Act comes on the scene, and he doesn't refer to the 1995 Act, so far as I can see, as being the foundation for introducing this concept of DRE. It comes in because it's a way of working out what is expenditure that is reasonably practicable for a person to be expected to contribute to the services provided by a local authority within Section 87(1) and then 1A. Is that not right? That is my understanding at the moment.
Well, my Lord, if that was correct, the position remains that it doesn't really affect the fact, in my respectful submission, that Second Division has misdirected itself in terms of DRE in the approach that it has taken.
Certainly, I understand you say that now we have the Equality Act, and so
yes,
the concept must be informed in some way by the duties there. But I think that what we're trying to understand is where DRE, this concept that we're all happily referring to, actually fits within the legislative regime that we have to operate.
I suppose to answer my Lord Sales, one can make an argument for disability-related expenditure under subsection 1A of 87 in the 68 Act, but one can also make a case for it in terms of the Equality Act. I suppose that's perhaps the logical kind of where we end up, and to be absolutely focused on the point of my Lord Sales here is that where does the DRE come from? Not quite sure where it comes from, but I'm sure that it can be argued from it could be argued from the Equality Act position or from being reasonably practicable. I fully accept that proposition.
Yes, thank you.
So just coming back to how this applied to Mr. McCue. So in 2018, Mr. McCue's only income was employment support allowance, and that was £127.15 per week, with disability allowance and mobility component of £59.75 per week, and DLA care of £85.60. And that could be found in the Respondent's decision letter of 14 August 2018, which confirms the charges that he was assessed to pay, and that's at EF page 262.
What was the third element?
DLA care component, my Lord, £85.60.
Thank you.
Now, so his total weekly income at that point was £272.50. At that point, he was allowed a DRE waiver of £6.25 for footwear and clothing alterations, but no other DRE was accepted by the respondent as being relevant, and he was then assessed to pay £21.10 per week to the cost of his community care.
how much was community care? I missed that. What was that?
He was assessed as paying £21.10 per week.
Thank you.
As a contribution, my lord.
Yes, thank you.
Now, as I've noted, the appellant has got additional living expenses because of his disability, and contends that the respondent's PCP in relation to his DRE discriminated against him as a disabled person because it treats him unfavourably, contrary to Section 15 of the 2010 Act. So,
I'm sorry to interrupt you, but can you just explain your elements on this in this calculation? We see his income from various benefits is 27250, and you drew our attention to the deduction of £6 odds for footwear, and then what are the other deductions for? I mean, I can read what's said, but what are they actually relating to?
As I've set out in my written case, my Lord President, the respondent as a local authority followed the DWP, the Department of Works and Pensions position, which is to allow somebody to live on a minimum amount of income. Mm-hmm. So there is a minimum sort of threshold. So there's tapers that are applied, so for example, as I noted earlier, DLA mobility is expressly excluded through Social Security law.
Right.
The care component and indeed the ESA potentially are open under this calculation to be assessed, but you're allowed to have a minimum level of income. And then what happens with the taper is, as I understand it, the local authority then take half. So they then decide what have you got as a minimum income, having regard to DWP criteria, and what over that you then have, they take half. And that's narrated in the respondent's charging policy itself, where it goes into the underpinning rationale of the calculation, and indeed in the COSLA guidance.
Yes.
And can I just check, is that deduction a matter of guidance, or are there regulations that take that out of the calculate, or that specified amount out of the calculation? So I rather understood from the explanation you gave about the deduction of DLA mobility that there was some legal rule in a regulation or something that took that out.
Yes, well, that comes from
All right. Perhaps that could be checked for us in due course rather than putting on the spot now and taking up time on it.
I don't know, my Lord. Section 73(14), so Section 73, subsection 14, Social Security Contributions and Benefits Act 1992. So that's in relation to mobility DLA. But coming back to my Lord's point about where does this all come from, my understanding is it is guidance, not a set of regulations. I could double check that though, because I think it's set out in the charging policy itself. I can double check that.
Right, thank you. If I may just observe, as we're looking at this calculation, one sees the deduction of the £6.25 for clothing footwear with the brackets DRE next to it,
yes,
which I think tends to bear out the idea that DRE is coming in as taking elements, in order to take elements of income out of the calculation,
yes,
leading to the contribution that is then assessed to be made.
Which, my Lord, I would say is exactly correct. But the only DRE at that point in time was that amount. And so the issue in terms of this appeal is the other aspects of DRE which were excluded in terms of the PCP, the practice of the respondent.
Yes, so in terms of subsection 1A of section 87 of the Social Work Scotland Act, they are accepting that it's not reasonably practicable for Mr. McCue to pay for services out of the £6.25 which he needs to spend on footwear by reason of his disability.
Yes, my lord, but one could also equally say, separately to that, is that the respondent is also adhering to its duties under the 2010 Act to make a reasonable adjustment in relation to
we haven't got to that yet.
We haven't got to that, my lord, but yeah, no, I think that's extremely helpful. Now, so again, just for the sake of clarity, yes, the footwear, clothes alterations accepted in terms of that 625, but not the extra costs in terms of the appellant not being able to use public transport or to walk somewhere on his own because of his disability, or they need to be accompanied by a support worker and the extra costs, or indeed having to not being able to do washing and ironing and so on and so forth. I should say, in relation to extra bedding costs to do with a skin condition, and we had submitted medical evidence that had been before the court, but just to simply note very, very briefly, I note that my learned friend, in her written case at EF page 78, footnote 13, accepts that the extra bedding costs from October 2019 were treated as DRE by the respondent, and so a further £2.50 was disregarded. So I understand that from my learned friend's written case that was actioned in February 2020. Now, that wasn't something that was before the second division. The second division reclaiming motion took place during full lockdown over WebEx, so it wasn't something that anybody was aware of at that time.
Footnote 13 says this adjustment was made in the light of new information. So what seems to have happened, at least on the authorities' case, is that new information is brought forward, which then, in terms of Section 87(1)(a), persuades them that, yes, indeed, that element is not reasonably available to bring into the calculation for any contribution to the services that the authority provides.
One could say that, my lord. However, to be fair to Mrs. McCue, the mother and guardian of Mr. McCue, that evidence had been set forth and vouched for, and it was a subject that was then obviously subject to litigation before the Outer House and the Inner House. And I had lodged not only the medical evidence, but evidence from, in terms of expert journals in terms of the link between Down syndrome and skin condition. So I think that persuaded the respondent. But one can see how it's very difficult for DRE to be accepted. If I can turn to, in terms of the Equality Act 2010, if I may, looking at section 15, which is in volume 1 of the authorities at tab 3.
The page number, sorry.
I beg your pardon. EF page 373.
Thank you.
So section 15 is headed up discrimination arising from disability. So a person A discriminates against a person B if A treats B unfavourably because of something arising in consequence of B's disability, and A cannot show that the treatment is a proportionate means of achieving a legitimate aim. Now, subsection 2 doesn't apply because clearly the issue of disability was known. My Lords, what the appellant says in terms of what's the something arising in consequence of his disability, that's the extra living costs that arise because of his disability. And of course that's the DRE that he set out and vouched for with written evidence. And the appellant's position is that these extra living costs arise on a 24-hour basis. Yet the second division, in its opinion, narrowed its consideration of DRE as only being able to arise from the care needs that it assesses under the 68 Act. And my Lord President, that's where I talked about, and I'd made the submission that the 1968 Act is a set of separate duties in terms of providing community care services. And those community care services aren't services for 24/7 hours of a day. So that approach of the second division, I respectfully submit there's no statutory basis for the second division to adopt that approach, having regard to the 68 Act and the 2010.
Well, that may well be right, even ignoring the 2010 Act, because we've seen it under the 1968 Act as amended. The charge has to relate to services provided to meet assessed needs.
Yes.
But the recipient's ability to pay isn't related to the assessed needs, but is based on what is reasonably practicable for him to pay.
Yes, my Lord, that's absolutely correct, and of course that's my Lord Sale's point as well, which I don't think I'd fully understood the force of that. I absolutely, my Lord.
Right. Okay.
So just developing my Lord President Reid's point there, if I may.
If I could also add this thought, the assessed needs are for community care services.
Yes.
And the ability to pay is related to the impact of disability.
Yes, my Lord.
And is there a definition of community care services? What exactly do they encompass? The section 12A duty is to assess the needs for community care services. And I was just wondering whether there's a definition of community care services.
There will be, my Lord. Perhaps we can come back to that.
Well, I wasn't able to find it.
Oh, well, we'll certainly have a look at that and try and come back to that this afternoon if we can.
Sorry, just on that, because I think it's quite important that we try to be clear about this. In fact, looking at section 87(1)(a), the test is whether it's reasonably practicable for him to pay. I mean, that's not necessarily related to pressures on his financing just from his disability.
No.
I mean, obviously, usually it will be.
Yes.
But other things might happen. You know, the roof of his house might fall down, and everyone would recognise he needs a roof over his head. That's nothing to do with his disability, but may mean that there's a substantial, if you like, prior claim on his finances, which means that it wouldn't be reasonable for the authority to assess that it was reasonably practicable for him to use that money to make a contribution.
Yes, my Lord. And so this kind of possibility of a life crisis, which obviously happens to people from time to time, sadly, that would cover something like that.
So,
Yes,
so your
equally-
proposition.
Sorry. Go on.
So your submission is that that he is entitled to have all extra living costs arising out of his disability to be, in effect, counted as DRE. Is that right? Is that the proposition? All extra living costs arising out of his disability.
All reasonable additional living costs, my Lord's boroughs, because I fully accept and I think it was my Lord President made the point, wanting to go on a around the world trip and bring somebody with you would certainly not be, could easily be found not to be reasonable. It would be very difficult to challenge that, I think.
I'm just wondering whether living costs actually adds anything. Or isn't it all extra reasonable costs because of his disability?
Yes, well, I think that is preferable. I'm obliged.
And you say that what was being claimed, I think it's set out at pages 178 to 179 is where I made a note of it. I think they are all disputed expenses, as I understand it. And we see, I think within there, I'm not quite sure about all the figures, but certainly it correlates the ESA at the top to the figure you've already showed us on page 262, £127.15. But it's then as we go down, it's the weekly outgoings. It's all these, is it? And then on the next page, we see the footwear and clothing alterations already accepted as DRE. That's the £6.25 on page 179. But I think it's all these effectively, is it? This is what the dispute was about.
Indeed, my Lord.
And some of the, as I understand it, there are, I think they're ticks, are they? The bedding at £3, has that been accepted? And the ironing cost at £11?
No, my Lord, I don't know who made those ticks. So the only costs that were accepted were the footing and clothing alterations at £6.25, and as I had noted, from I think February 2020, backdating to November 2019, the bedding, but not at the £3, I think.
It was £2.50.
£2.50.
Right.
But none of the other.
It may not matter. I'm just a bit puzzled how one gets to the share of a holiday at £17.30, for example. Andrew's share. There's a large cost there. How does one get to £17.30? Don't take time now if it's not immediately obvious. But I'm just a bit puzzled by those sums.
I'm obliged, my Lord.
And similarly, the Lourdes holiday support, how you get to a figure of £14.
Yes, my Lord. We can try.
Is it that some sort of larger figure is being divided by 52?
I understand.
Is this a sort of claim in relation to a weekly calculation? Is that what we were looking at before?
Yes. Yes, and I think what Mrs. McCue, as the mother and guardian, is trying to do is to take out the bit that pertains to the extra disability aspect of it. But I fully accept, my Lord Borough's point, which is, one needs to see the mechanics of that, but clearly it was rejected. Just to come back, if I can, to my Lord Stephen's question, and I think we have to thank our The respondent, in terms of community care services being defined, I understand it's page 359, section 12A8. Yes, so in this section on page 359, community care services means services other than services for children which a local authority is under a duty or has a power to provide or to secure the provision of under Part 2 of this Act. That's the 68 Act. And then there's other provisions.
That's somewhat circular, isn't it?
I think so, yes. I understand there's quite a general set of powers to provide community care and social welfare services under the 68 Act. Now, as the party statement of facts and issues confirms, the respondent provided community care services Monday to Friday 9 to 3, so that's 30 hours each week in a day centre, and that's at EF page 49. And as I've noted to this court, there's still 138 hours in the week. Section 15, the appellant would contend that the threshold for unfavourable treatment is a relatively low threshold, and I would rely...
Well, unfavourable treatment compared with what?
Well, unfavourable treatment, if one goes back to Section 15, my Lord President, it's something that arises in consequence of B's disability.
Well, that has to be the reason for the unfavourable treatment, that treats B unfavourably because of something arising in consequence of B's disability. But I mean, one might have thought, no doubt there's a vast quantity of law on this, but just looking at what's said, a person discriminates against a disabled person if the person treats the disabled person unfavourably.
Yes.
Because of something arising in consequence of his disability.
Yes.
One might have thought this was to do with a comparison between disabled people and people who weren't disabled.
But, my Lord, with respect, it's not, because the Act provides for comparator groups. So there's specific sections of the 2010 Act that require you to have an able body comparator to make out a case of discrimination. Interestingly, Section 15, there is no comparator. It's the only provision.
So what does unfavourably mean?
It means to be put at a disadvantage. And I was going to take...
Or is it meaning less favourably than would have been the case in the absence of the something arising in consequence of a disability?
I think that would make sense, my Lord. I mean, I think what I'd noted earlier is the something arising in consequences of the extra costs, the reasonable extra cost that I think Lord Burrows had framed.
But it has to be the treatment of...
Yes.
And the treatment here is the application of a policy.
Yes.
And so one's not looking at the extra cost, one's looking at the treatment.
Yes.
You have to define the relevant treatment, and then you have to ask, was it unfavourable to the claimant? And the respondent's simple answer to that is the treatment is the application of this policy, which allows for discretionary payments to be made, and that was a benefit to the appellant. It wasn't unfavourable at all.
But, my Lord, the appellant's position to that is, I have these additional costs. because of they arise out of my disability, and because of your policy, your practice, the PCP, you exclude them. You've got different reasons to exclude, and I say that puts me at a disadvantage, and that treats me unfavourably because of my disability, because the disability benefits that I get to have an independent life are reduced by your charges.
Well, take an example, the bedding. Because it's a very simple example. I mean, we know now that the council accept that the cost of additional bedding is properly treated as DRE, but it wasn't initially. So there's something arising in consequence of B's disability, I think, is the additional cost of bedding arising in consequence of the disability because of a skin condition.
Yes.
That's fine. So how could the council be said to be treating Mr. McCue unfavourably because of either the additional cost of bedding or the skin condition itself, whichever you treat as a something? How's it treating him unfavourably because of that?
Because, my Lord President, they didn't take that into account when they calculated the charging decision under the Social Work Scotland Act.
But that's not treating him unfavourably because of his additional costs or because of his skin condition. Is it?
Well, my Lord, I would respectfully say it is because if one accepts, and I think the bedding is a good example, this is an additional reasonable cost that comes about because of the disability. And the appellant asks proactively for cognizance of that to be taken, in order for that to be taken into account for the charging decision, which would then mean the appellant has to pay less of a charge. And this is why I come back to it. I think Lord Stevenson made the point about double. Well, if one has that taken into account, then one uses the Social Security money to pay for that, and one is not then charged, so that money's taken away. So I don't see any double effect. But what I do see, if that's not the position, then the unfavourable treatment is that Mr. McCue has a fixed minimum sum of money in terms of Social Security to live on. He has to pay these costs out of that, but the respondent comes along and takes some of that money away. So he's in a worse position because of that. A
straightforward example of the application of 1A would be if the council refused to employ Mr. McCue because of his skin condition.
Yes, that would be a straightforward.
That would be treating him unfavourably because of something that arose in consequence of his disability.
Indeed, my Lord, and I think, to be fair, in terms of the Equality and Human Rights Commission, in terms of their statutory codes, they recognise, and we have this in the bundle, they recognise, my Lord President's example of a very clear-cut, very easy to see disadvantage, but they also say that there could be ones that are much more subtle and indirect in their guidance, and that is statutory guidance.
I mean, I think the conceptual difficulty that I'm having is almost brought out by the fact that you describe DRE as a waiver. A waiver would axiomatically appear to be beneficial. So we're in the context of something that is being done beneficially for the person. One's granting a waiver, and then it looks as if all we're talking about is the extent of the waiver, the extent, in other words, of the benefit. And it's hard at the moment, conceptually, to see that that could be regarded as disadvantageous.
But with respect, my Lord Burrows, that's the descriptor that the respondent uses. So it's a bit circular. So the respondent says waiver, and the respondent says it's a benefit. In relation to that, the appellant's position is, well, no, it's not a benefit. That's not the way to look at these things. With respect, the way to look at these things is that there's a statutory duty under the 68 Act to provide community care services. And as we've discussed, in terms of section 87, subsection 1, it has to be reasonable to pay, and then subsection 1A, reasonably practicable, which opens up various potential factors. Then we also have duties under the 2010 Act, specifically in relation to disabled persons in relation to section 15. And that is an additional duty. And what I say is that the way to look at this is to say, that the appellant has these additional living costs, these reasonable living costs because of his disability, and if you don't make reasonable adjustments, and I'll come on to the reasonable adjustment section 20 in a moment if I may, if you don't make a reasonable adjustment to take that into consideration, not provide a benefit, but to realise that Mr. McCue has to pay these extra things in real life, then he's going to be at a disadvantage. I think, my Lord Burrows, that's the way I would...
What is the treatment that we're concerned with? I can understand that under the 1968 Act there's a duty on the local authority to assess needs and to provide services, community care services. As part of that, it could be said there's a further benefit conferred in terms of not requiring deduction, in not requiring payments to be made, in permitting deductions to be made from the cost that would otherwise be payable.
One could look at it like that in terms of, I accept my Lord's point.
So is the treatment with which we're concerned for the purposes of the Equality Act permitting the deduction?
My Lord, I would submit that the treatment, so that in terms of what underpins the 2010 Act, is for, under section 15, is for a disabled person to not be treated unfavourably, which means to be not put at a disadvantage because of disability. And so my answer to my Lord Lloyd Jones on that point is that in recognising reasonable DRE, Mr. McCue isn't put at a disadvantage. He can use his social security income to pay for those costs, and that's fine. And the council will provide community care services under the 1968 Act. But Mr. McCue can pay for these extra costs out of the money that comes via UK Social Security.
I understand that's the way it works, but what do you say is the treatment for the purposes of 15(1)(a) and b?
The treatment is the provision, criteria and practice of the respondent. So the practice of excluding DRE for the three reasons which I think I've set out are quite flawed.
But that's not. But that practice can't be said to be because of something arising in consequence of his disability.
Well, with respect, my Lord, surely it can be, because if the DRE only, if these extra costs only arise because of disability, then surely...
Well, you're eliding, you're ignoring the words because of. You're effectively rolling up together the treatment and something arising in consequence of disability, and omitting the need for a causal connection between the one and the other. I mean, if for example, Mr. McCue likes to go to a snooker club.
Yeah.
And so there are taxi fares involved. I don't know if he also needs to be accompanied, I can't remember.
Yes.
Right, so, okay. And the local authority are unwilling to pay, I think, both of those.
Yes, indeed.
Okay. So you would say the treatment is what? The refusal to classify the expenditure on taxis to the snooker club and the cost of a carer accompanying him to the snooker club as refusal to take that into account as a deduction from his income for the purposes of Section 87(1)(a) of the Social Work Act.
Yes, my Lord.
Okay, so if that's a treatment, you can't say that treatment, that refusal to take account of the expenditure, is because of something arising in consequence of his disability.
But surely, my Lord, none of this would exist or happen but for the fact that Mr. McCue is disabled.
Yes, but I think Section 15 is concerned with the reason for the unfavourable treatment.
I fully
for example, if they refuse to employ him because they don't like him,
yes,
that's not relevant to Section 15. The refusal to employ him has to be by reason of his disability,
yes,
or something arising in consequence of the disability, for it to be relevant under Section 15.
And I think to address my Lord President's point in that regard, I would say that if one considers the construction of Section 15, subsection 1A, I would respectfully submit that it lends itself to my Lord President's example of the more obvious, you've not given me a job because I'm disabled. But in my respectful submission, it also lends itself to something that's more subtle, which is something that arises, which is these additional costs. So
but you're not. You see, you can't say the council are refusing to treat the cost of going to the snooker club as DRE because Mr. McCue is disabled. I mean, the Act is about equality, so it's about equal treatment ultimately. So you're looking at the reasons why people are treated in the way they are.
But surely then, just to flip that position, my Lord, you could say not taking into consideration these additional disability costs results in the respondent making a higher charge.
Yes, but they're not charging him, if you like, they're not charging him more for the services they provide because of his disability or something arising in consequence of his disability.
I fully accept they're not doing that because of his disability, but I would respectfully submit one can construe that it does still fall within arising. I take my Lord's point in terms of the statutory construction, but I think the danger if you took a too narrow approach would be that then Section 15 would only cover those very egregious.
Yeah. So your submission is really that giving it a purpose of construction you arrive at your position, and the construction that I was putting to you is overly literal, I suppose.
With the greatest respect, Lord.
Yeah.
If the treatment, going back a step in time, if the treatment is permitting deductions to be made, then I have difficulty at the moment in saying how it's unfavourable treatment. Which I think your complaint is that deductions. That your complaint really is that the deductions should be provided for more generously.
Not quite, my lord. It's because of the very. It's because these additional disability costs, given the second division's approach, and given the practice of the respondent, can only arise in very, very limited circumstances. That I submit is the flaw in the error.
Well, that might be right if the inner house was correct in its view that the provision only applies in respect if it operates within the scope of the assessed needs.
Yes.
But it might be that that's not right. It might be that the scope of its application is more generous than that, or should be more generous than that.
Yes, my lord, and I think that is the appellant's position, which is that the scope is wider with respect to the discussion that's already taken place. And if that's so, that then results in my respectful submission, that the practice and the policy of the respondent is discriminatory and is flawed.
But isn't your complaint really that more generous allowance should be made?
I'm hesitant to say more generous allowance, my lord, because there are particular categories that are just simply excluded. So more generous.
We can put it a different way and say that other categories of deduction should be permitted.
Yes, my lord, I would fully accept that analysis.
I thought that your argument was that the treatment is the application of DRE, that the way that treatment was formulated placed a hurdle in the path of the disabled person, because it required the application of a test of an essential or necessary expenditure related to disability. And so the favourable treatment test, which was suggested by Langstaff, Mr. Justice Langstaff, and then quoted with approval in Swansea, paragraph 24, is unfavourably in the sense of placing a hurdle in front of or creating a particular difficulty or disadvantaging a person. And so I had understood you to be saying the disadvantage or the hurdle was imposing a requirement of essential or necessary expenditure.
I'm obliged, my lord. That's a more concise way to analyse the position. I do think there's different facets of it. Coming back to my Lord Jones's analysis. I suppose either way you look at it, the appellant's position is the respondent has got it wrong, and the second division has followed that approach. I'm just conscious of time. Just in terms of the threshold test for being treated unfavourably, I do cite in the written case the case of Williams from this court. So that's in the written case. that gives authority to that proposition. I think I've noted that the appellant would submit the idea of considering the charging policy providing a benefit is the wrong way to look at this in terms of the legislation in the 2010 Act. Very briefly, I would note that the respondent sets out an ESTO defence position in its written case at EF pages 78 to 79, which is the proportionality defence. My Lords, I deal with this.
And just perhaps it might be helpful to explain to those who aren't familiar with Scottish Latin. It simply means if I'm wrong on the first point,
Yes.
my fallback argument on the second point is as follows.
Indeed, my Lord. Indeed. And I deal with that at paragraph 3.6 of the appellant's written case, at EF page 61, the appellant says there's no written pleading setting up such a defence. And I make reference to this court's decision in Astor Communities Limited, which is tab 6, volume 2 of the authorities, EF 456, paragraph 28, in terms of the 4 questions that need to be addressed in terms of that defence. My Lords, if I can perhaps briefly turn to section 20, which is the duty to make reasonable adjustments. In section 20 can be found in volume 1, tab 3 of the authorities.
Do apologise. What's the page number, please?
The specific page, my Lord, is 374.
Thank you.
And section 20 requires a duty to make adjustments. Subsection 1, where this Act imposes a duty to make reasonable adjustments on a person, this sections 21 and 22 and the applicable schedule apply. And for those purposes, a person on whom the duty is imposed is referred to as A. And then the duty comprises of 3 requirements. The appellant's only pled a case on the first requirement, which is subsection 3, section 20. And that is...
What's the provision in the Act on which you're relying, which imposes the duty to make reasonable adjustments?
It comes from paragraph 2 of Schedule 2 to the 2010 Act, my Lords, which can be found at EF page 383.
Oh, fine. Okay, well, we'll come to that. Right, you'll take us to that in a moment.
It's quite a curious way of drafting, because one sort of searches, well, how... It's all very interesting, but where does this duty get imposed from? But one can see that section 20, subsection 1, talks about the applicable schedule. Perhaps I can look at that schedule just to deal with my Lord President's point. So at 383...
I'm sorry, just... where do we find... section 20 takes us to the schedule, does it?
Just trying
The applicable schedule.
I'm just wondering how we get taken to Schedule 2. It must
Yes,
be...
my Lord, if one looks at EF page 375,
Yep.
Subsection 13, in section 20, the applicable schedule in relation to the part of this Act specified in the first column of the table, the schedule specified in the second column. So for services and public functions, it's Schedule 2.
Well, hold on. Yeah, well,
I suppose the way to think about it, my lord, is that Section 20, in terms of the duty to make adjustments, is quite far-reaching.
Well, it doesn't impose any duty, you see, Section 20.
But my lord, because in relation to services and public functions, it refers to Schedule 2. If I can take the court to
No. Where this Act, I mean, look at subsection 1. Where this Act imposes a duty to make reasonable adjustments, this section, sections 21 and 22, and the applicable schedule apply.
Yes.
And the provision at the end of the section tells us the applicable schedule for public functions is whichever schedule it was, Schedule 2. But the starting point is that there has to be somewhere in the Act that imposes a duty in the first place.
And that's found in the schedule, my lord, which seems odd, but there you have it. If one looks at EF...
But the schedule doesn't apply unless there's some... the schedule only applies if the Act imposes a duty to make reasonable adjustments. I can't help wondering if there's a bit more to the Act than we're looking at.
Well, if I could take the court to EF page 383,
Yeah.
paragraph 2, Schedule 2. A must comply with the first, second and third requirements. And as I've noted, the appellants only made it a case on the first requirement, which is where a provision, criterion or practice of A puts a disabled person at a substantial disadvantage in relation to a relevant matter in comparison. So there is a comparison test in this section with persons who are not disabled to take such steps as it is reasonable to have to take to avoid the disadvantage. Substantial is defined in section 212, subsection 1, to mean more than minor or trivial, and that's at EF page 380. In my respectful submission, the second division ought to have followed the approach of the England and Wales Court of Appeal in Griffiths against the Secretary of State for Works and Pensions in its construction of the 2010 Act. And Griffiths can be found at tab 8.
I'm sorry, just before we come to that, I think I found the answer to my own question. I think it may be section 29 of the Equalities Act, which is concerned with the provision of services, and in subsection 7 says a duty to make reasonable adjustments applies to a service provider, and B, a person who exercises a public function which is not the provision of a service to the public or a section of the public. That may be the relevant provision, but the point really is we need to find somewhere a provision that imposes a duty in the first place before section 20 and schedule 2 arise.
Yes, my lord, I'm obliged. If I can come back to my lord on that point, perhaps this afternoon as well. So I'd asked the court to look at the case of Griffiths, EF page 525 in volume 2. and this is paragraph 58. Reading from first, the language of section 20 is very different from the language in section 24 of the Disability Discrimination Act 1995. The nature of the comparison exercise in the former case is clear. One must simply ask whether the PCP puts the disabled person at a substantial disadvantage compared with a non-disabled person. The fact they are treated equally and may both be subject to the same disadvantage when absent from the same period of time, this is in relation to the facts of that case, does not eliminate the disadvantage if the PCP bites harder on the disabled or a category of them than it does on the abled body. And so the appellant's position is the respondent's PCP in relation to DRE's charging policy does bite harder on him because of his particular disability. And I think that's an important point.
Harder on him than on who else?
Than on somebody who is not disabled and somebody who doesn't have his particular disabilities. Because his particular disabilities, one can think of an example of somebody who has a physical disability, which is not including a learning disability, where one can obviously then go about life without needing the support of a carer. So there's all sorts of potential possibilities. And what the appellant...
But sorry, section 20, subsection 3, and indeed Griffiths, seem to be looking at a provision criterion or practice which is applied apparently uniformly across, if you like, the whole population, so disabled people
Yes.
and people without disabilities, and but it has a significantly worse effect. Its application has a significantly worse effect in relation to a person who's disabled than it does in relation to a person who is not disabled. That seems to be the thrust of talking about it bites harder on them or a group
Yes.
of them.
Yes, my lord.
But in our case, we're not dealing with a provision criterion or practice that applies across the board in that way. It just applies to disabled people, doesn't it?
Well, not quite, my lord, because the charging policy applies for all social work services. So it's a charging policy in relation to services provided in terms of community care, whether under the 68 Act, welfare services, for example, home...
But the issue is with the DRE,
Yes, indeed, my lord.
and the DRE only applies to disabled.
Yes, my lord. I was just thinking of the example in terms of my lord's Sale's point of people who are elderly in supported accommodation, you know, where they get charged for example, alarm services and so on and so forth. So the charging policy applies across the piece. And what I've sought to develop is the respondent, in my respectful submission, hasn't properly identified how its PCP does put the appellant at a substantial disadvantage by not making reasonable adjustments in relation to his additional reasonable costs as a disabled person. If that proposition is correct, then that constitutes unlawful discrimination in terms of section 21 of the Act, which is at EF 376. There's a burden of proof provision in section 136 of the 2010 Act, and that's at EF page 377. And my understanding of the position is that where somebody sets out how reasonable adjustments could be made, then one can shift the burden of proof to the respondent. And I make reference in my written case to the case of RVC against the Secretary of State for the Home Department, which is at EF page 687. And I make reference to paragraph 161, EF page 687, where in this case there are facts from which the court could decide that the Secretary of State contravened the duty to make reasonable adjustments. This is because, as is common ground, the duty arose because no adjustments were in fact made, because the claimant has outlined adjustments.
Sorry, you're reading from paragraph?
Paragraph 161, bottom of the page of 161 on EF 687.
Very much.
So the claimant had outlined adjustments which could have been made, and therefore the burden is therefore on the Secretary of State to show that she complied with her duty to make reasonable adjustments. And all I simply note in that position is that the appellant has set out DRE my Lord, if I can turn to my second chapter, which is reasonably brief, and ask the court to consider the second division's opinion, which is at EF page 107, which is in the core volume. So that's 107, paragraph 51. And looking at this, so the second sentence, it seems to us, indeed, the whole purpose of paragraph 12.2 of the charging policy is to enable the authority to discharge the obligations imposed by the 2010 Act in respect of those requiring community care who come within the scope of that Act. And a little bit further down in that same paragraph, beginning with the words, it does so. So it does so by recognising that notwithstanding that there has been an assessment of his needs, and in this case one which is accepted as being sufficient for Andrew's needs, there may be some essential disability-related expenditure associated with those needs which may have been overlooked or otherwise slipped through the net. The effect of the 2010 Act is not to create some entirely different obligation on authority to pay for disability-related expenditure which does not relate to the services provided by them under the 1968 Act. Now, my Lord, what the appellant says with great respect is that that was the wrong approach to the duties under the 2010 Act. And I think, given the discussion that we've had this morning, I would further submit was the wrong approach in relation to Section 87, subsections 1 and 1A, separately. There was a duty to avoid unfavourable treatment, to make reasonable adjustments, to prevent substantial disadvantage. And it's not about requiring the respondent to pay for DRE. I mean, the appellant's not saying, could you pay for me to go to have a holiday? It's about the extra bits in terms of, well, I need a carer. because of my disability.
I mean, I'm not sure that one gets from this paragraph an error in relation to section 87(1) and 1A. And paragraph 12.2 of the charging policy, I think just said, we will entertain representations from people which may be relevant. So that would be a mechanism for allowing people to come forward with evidence to show or support their case that it's not reasonably practicable for some element of their income to be used in relation to a charge for support services. And then in the latter part of this paragraph, what the court seems to be doing is referring to specific deductions in the calculation, and you showed us the calculation and helped us with some elements which seem to be, at least some of them, mandatory according to law.
Yes.
And then they just say, and there may be some elements that should come out of the calculation of available income for other reasons. I think, as they put it, otherwise slip through the net. In other words, were additional reasons apart from those mandatory deductions why they should be taken out of the available income. And just looking at it from the point of view of section 87(1) and 1A, that, speaking for myself, doesn't seem to be wrong as an approach. I appreciate you say they've also gone wrong about the Equality Act, but can you help us any more in relation to the interaction of paragraph 12.2 of the policy and section 87(1) and 1A?
I think my Lord Sales, where the second division has went wrong is that it only allows for DRE in relation to the care needs as assessed by the respondent. So in terms of that paragraph that I quoted to my Lords, it's referring to essential disability-related expenditure associated with those needs. Those needs are the needs as assessed under the 1968 Act for Community Care. But as had been pointed out, I think by my Lord President, the assessment of care needs under the 1968 Act is one thing, but which is much more narrow than the assessment of the test under section 87(1)A in terms of is it practicable to pay those costs, or under 87(1), is it reasonable? And I think the point that my Lord President Reid had made was that in terms of the practicality and the reasonableness, that includes a wide scope, and I can't remember if it was my Lord Sales that had made the point about it's actually wider than just disability. It could be calamities in life. So with respect, what the appellant says is that the second division has taken a very restrictive approach in that respect. And I think in relation to the 2010 Act, what I say in that respect is that these are separate duties to consider. And I do think that the second division conflates the 2010 Act by making it effectively subject to the 68 Act care assessment process. And with respect, what I say is that cannot be right as a matter of statutory effect, because how could the 2010 Act be limited by the 68 Act unless there was an express provision?
Would you say to a possible interpretation of what's being said here that it's a distinction between essential disability-related expenditure and presumably non-essential disability-related expenditure? As I understood your early submission, you're talking about reasonable extra costs.
Yes,
and is that the point you would make, that one cannot confine it to essential disability needs?
Yes, my lord. Yes, I mean, essential doesn't appear anywhere in either Acts of Parliament. But the effect of that approach is to have a kind of telescopic restriction on what can be relevant in relation to whether under the 68 Act or the 2010 Act.
I mean, a distinction might, you might say, be drawn between the necessities of life, so to speak,
Yes.
and leisure and social activities that might be regarded as a matter of choice for the individual rather than necessities of life.
Although those concepts don't, with respect, my lord, appear in the legislation, and I would respectfully submit that yes, there's limits, and that's why I'd thought about it has to be reasonable. But the underpinning approach of our UK social security system and disability benefits has always been about, and indeed the community care system, has always been about enabling somebody to live with a minimum amount, and if one is disabled, to be able to lead an independent life. And that's why one has these statutory duties. But the notion of essential is very restrictive in my respectful submission. And I think it's fair to say the respondent's written case sets out a position which one might describe as if you don't adopt an essential criterion, somebody could game the system. You know, somebody could decide to go to Australia and run up costs that would then mean no charges. And what I say to that, with the greatest respect, is that that's fanciful, because we're talking about people that are severely disabled living on social security benefits. So the idea that you, on a small amount of money, can have those kind of expenditures is, with respect, not an issue. And I take no challenge to the fact that if somebody was being unreasonable, then of course any local authority would be able to disregard that. So, my lords, I think I made the submission already that I think the Griffiths approach by the England and Wales Court of Appeal is the correct approach in terms of the 2010 Act. Just very quickly, in terms of paragraph 51, the second division talk about minimum income thresholds and income buffers. My submission is that, I'd say that that's an implementation of the 2010 Act. With respect, I see that is incorrect, because the minimum income thresholds and income buffers apply to social work services generally, whether you're disabled or abled. And that could be found, as I say, in the respondent's charging policy and the COSLA guidance. So that's nothing to do with being disabled. I made the point about mobility, disability coming from the Social Security Contributions and Benefits Act 1982. So again, that's nothing in the charging policy. It's a matter of UK law. If the second division had applied a correct construction under the 2010 Act, I would submit that it would have concluded that the charging policy and the practice in terms of the PCP did discriminate against the appellant. when one looks at sections 15, 20 and 21. My Lords, just again very quickly, the charging policy at 2.2, and I won't turn this up, it's at EF page 192 in the appendix, essentially says that the respondent's policy complies with COSLA, the national guidance, which is non-statutory guidance. And I simply say in that respect, it doesn't, because if one looks at the COSLA guidance, it's EF 732 to 733, and I think it's useful just for a brief look.
That guidance doesn't contain anything about it being essential.
Indeed, my Lord. I mean, I won't labour this point, but I think the point I was seeking to make, and I'll do this very quickly.
And if they were following that guidance, they would have come to the conclusion in relation to bedding a little bit more rapidly, perhaps.
Yes, my Lord. I think that's absolutely right. So I just the COSLA guidance, in my respectful submission, the COSLA guidance is more similar to the approach that's taken in the rest of the UK in relation to DRE. So what you see here in 6.32 on EF 732, there's a reference to failure to take disability-related expenditure into account as part of financial assessment could result in charges levels which cause financial hardship and undermine the rights of people living with an illness or impairment to live independently. And then further down, 6.34 gives examples. Additional costs may relate to but are not restricted to specialist clothing, help with cleaning or other domestic tasks, if that's something the person would have undertaken themselves but can't. Extra washing, additional bedding, as my Lord Stevens has pointed out. And then finally, difficult to set anything because it varies on a person-by-person basis. I'm coming near to the conclusion of my submission. So I do think the COSLA guidance takes an approach which is closer to that found in RB against Cornwall Council, and that's at tab 10 of volume 2, and the key references are EF pages 581 to 582. I won't turn up that case. I have set it in my written case, my Lords, but it is interesting that in RB the High Court accepted the cost of an accompanying carer of a disabled person with respect to a holiday could be DRE in England. Lords, in terms of Chapter 3, that's a very, very succinct proposition, which is that if this court was to...
Sorry, just before you go there, I'm very sorry to interrupt. I'm just still looking at the COSLA guidance. Your point is that 634 on page 732, additional costs may relate to, but what will not be restricted to.
Yes.
I mean, there's no significance, is there, on your view, that there's nothing said about leisure or holiday activities?
No, I don't think so, my Lord. I mean, I think COSLA has recognised that you can't be prescriptive because one has to consider the individual case-by-case basis. Because, and I go back to 6.32, which is what is the rationale? The rationale is to enable people to live independently, and you have to consider their circumstances as they arise. And some people will have very minor, possibly none, in terms of additional costs, and other people with more severe and profound disabilities will have more. The Chapter 3 was the proposition, my Lord, which is that if the court was to find that the appellant's grounds of appeal were well founded, then clearly the petition must have been amenable to the supervisory jurisdiction of the Court of Session. That must be right. It must have been. within the ambit of judicial review. So in conclusion, I would invite the court to allow the appeal for the reasons set forth in the written case for the appellant and my submission this morning. And unless there's anything further I can assist with, my lord. And I do apologise for going over my allotted time a little.
Just thinking about leisure and holidays and so forth again. In terms of Section 87, 1A, the person has to satisfy the authority providing the service that his means are insufficient for it to be reasonably practical for him to pay for the service the amount that he would otherwise be charged. So he has to satisfy the local authority that his means are insufficient by reason of his expenditure on snooker clubs, journeys to Lourdes, and so forth. And so the local authority have to form a view about that, which comes down to a view as to reasonable practicability.
Yes.
And if they took an unreasonable view, then in principle that's something that might be challenged by judicial review, I suppose.
I think so, my lord, and I think that's the answer to what's reasonable, what's unreasonable, and that's traditional judicial review case law, and it's a high bar in terms of rationality.
Yes, and their duty. The provision ends up by saying that they shall not. So their duty is not to require him to pay more than appears to them that it's practicable, and no doubt that one could read that as being reasonably appears to them that it's practicable for him to pay.
Yes.
Yeah. Okay.
But you would say that threshold of irrationality and unreasonableness is crossed in this case, would you?
I would, my lord.
I don't think that's an argument that's been run until now, is it?
Well, it's not something that's been founded upon, my lord, but it was just in terms of my lord Burrow's point, in terms of where does this, just in terms of, well, how does this all operate? That's where we end up potentially, I guess.
Yes. I mean, your argument, both in the courts below and in your written case in this court, and your grounds of appeal as well, I think are all directed towards the impact of the Equality Act.
Yes, my lord, and how the Inner House approach to that conflated the 68 and the 2010 Act.
Yeah.
I mean, I fully accept that what's come out from this morning, and I think it was. I think it was my Lord Sales, who and then my Lord President Reid, this position in terms of looking at the actual Section 87 itself is another avenue, which I hadn't, to be fair, I hadn't properly appreciated until.
Yeah.
I mean, I think it would be fair to say that if there had been a rationality challenge to the actual decisions that were made, one would have seen ordinarily much more material from the local authority to meet that challenge, rather than just, was it answer 9 that you showed us, which didn't go into any detail at all.
One potential impact of the Equality Act is that under the 1968 Act, the obligation is on the disabled person to justify the reduction and to bring evidence forward. That might be seen as a policy criteria or practice which would operate unfairly to those people who hadn't got the ability to articulate or to understand or to make a claim, and which might need a reasonable adjustment to be made to that particular policy and practice. And that seems to be what the English guidelines suggest. That is, that there is, and indeed the COSLA guidelines, that there is proactive engagement by the local authority, as opposed to sitting back and waiting for something to be produced.
I think my Lord Stevens is absolutely correct, because the example we had of the bedding is perhaps illustrative of that point, which is that it's set out by the appellant, but it's only when we get to litigation and the medical evidence and dermatological articles from learned journals are lodged to say this is actually related to disability, that we then the respondent accepted that. So I think that's a good example of the point my Lord Stevens has made.
But if the onus is cast on the applicant by the primary legislation in section 87(1)(a), then that's not going to be a provision, criterion or practice of A's of the alleged discriminator, which is what is required under section 20 subsection 3.
Yes, although one gets an interesting point when, as in this case, the appellant does provide some vouching, but it's rejected without any further, taking my Lord Stevens' point, which is that a more proactive approach from the local authority would have been to make inquiries based on what had been the information given to it. But what one finds happens in Scotland in these cases, because I do see a big distinction between what happens in Scotland and what happens in the rest of the UK, is that people either don't know about the whole thing about DRD, or some local authorities don't even have forms to fill out. And one tries, as a parent of a disabled person, to have this progressed, and things are rejected, and there's no investigation by the respondent. So, I'm obliged.
Thank you very much, Mr. Daly. Ms. Crawford.
Thank you, my Lords. My Lords, on behalf of the respondent, Glasgow City Council, I would invite the Court to refuse this appeal. In making that motion, my fundamental proposition is this: that the local authority, the respondent, in deciding under section 87(1) and 1A what charges to recover if reasonable, that's section 87(1), and thereafter, having considered material provided by the appellant, whether it was practicable for him to pay what was otherwise determined as reasonable under section 87(1)(a. In making those decisions and exercising its functions under the 1968 Act, the respondent did not treat the appellant unfavourably and did not place the appellant, I'm using appellant as a broad term, obviously it was Mr. McCue himself, but Mrs. McCue has raised this appeal as his guardian, did not treat the appellant or did not place the appellant at a substantial disadvantage. The phrase favourable, unfavourable treatment, I should say, is to be found in section 15 of the Equality Act, to which this court has been referred earlier, and the phrase substantial disadvantage is the phrase to be found in section 20 of the 2010 Equality Act. Before proceeding to advance some submissions on both sections 15 and section 20, I can't help but make this observation, which I confess I was thinking about when preparing my submissions for this court, but it's been drawn out by this morning's conversation, that the challenge made by the appellant is in effect a rationality challenge, but the appellant has sought to shoehorn that into the box provided by sections 15 and section 20. And just to pick up a point which my Lord Sales made, had a rationality challenge been made at an earlier stage, then I think I can submit to this court with some degree of confidence that there would be far more material before this court as to why certain items were disregarded. And perhaps the most obvious example of that is in relation to the extra bedding costs, which is noted in footnote 13 of the respondent's case. The initial claim for those was said to arise in respect of Mr. McCue's eczema, I should say, rather than as a result of his Down's syndrome and the needs he has as a result thereof. The short point to make is that disability, of course, is described or defined, I should say, in section 6 of the Equality Act. I needn't take my lords to it, but section 6 is to be found in the bundle at page 372. And if I can just read out section 6. 1. A person P has a disability if A, P has a physical or mental impairment, and B, the impairment has a substantial and long-term adverse effect on P's ability to carry out normal day-to-day activities. The point I make is that seeking extra bedding arising from a condition such as eczema, rather than Down syndrome, it was perhaps unsurprising that the local authority took the view that that did not arise as a result of disability. No doubt it's an unfortunate and uncomfortable condition, but does not normally have a substantial and long-term adverse effect on the ability to carry out normal day-to-day activities. However, further information was provided, medical information, linking that skin condition with Mr. McCue's Down syndrome. Now, I simply provide that narrative to highlight the fact that were this properly a rationality challenge, considerations such as that would be before this court, and no doubt there would be an affidavit from the relevant social worker. My lords do have before them a detailed care plan, and one can see working through that a detailed assessment of Mr. McCue's needs and requirements. My lords, with that introductory proposition and introductory remark about this is truly, in my submission, a rationality challenge, I wonder if I might now turn to look at section 15 of the Equality Act. In my submission, this raises, in the words of Lord Carnwath in the Swansea case, two simple questions. Firstly, what is the relevant treatment? And secondly, was it unfavourable to the appellant? I mentioned I was referring to the words of Lord Carnwath in Swansea. My lords will find that at page 704, paragraph 12. And those questions are figured by the respondent in its case, albeit that the written case before this court asks, first of all, what is the treatment? Secondly, was it unfavourable? And thirdly, if unfavourable treatment has been identified, did that arise in consequence of disability? Now, it may be that Lord Carnworth's two questions and his identification of relevant treatment is meant to encompass, the word relevant is meant to encompass that third question, did it arise in consequence of disability? But clearly, in my submission, and I think my Lord Reid was having this discussion, there has to be some sort of causal link between the unfavourable treatment and the disability in question. Those questions are answered in the respondent's case at paragraphs 9 to 14, and I can summarise those answers if I may. First of all, as regards the treatment, it is the charging exercise and the availability of deducting what is being described as DRE from what would otherwise be determined as a reasonable charge. My learned friend sometimes describes that as a waiver. In answer to the second question, was that treatment unfavourable? The respondent submits that it was not unfavourable. It, in fact, represents a benefit to Mr. McCue, which he would not be able to claim if he was not disabled. But if my lords are against me on those first two questions and comes to the view that the treatment is something other than I've described, or indeed if it is as I've described but nonetheless is still unfavourable, I would answer the causative question to this effect, that that unfavourable treatment does not arise in consequence of Mr. McCue's disability. Putting matters shortly, the respondent does not say to Mr. McCue, you are not getting further or more benefit, you're not getting further deductions because you are disabled. Rather, as we've seen in the papers, the respondent says that as regards the disputed items, these are discretionary items, perhaps for use in leisure or social activities. And I don't wish to use the word discretion in any pejorative sense, but nonetheless they are discretionary items which you've chosen to spend your money on. And the costs arise not because of the disability, but because of those no doubt perfectly valid discretionary choices to go to concerts or clubs or whatever it might be.
So the treatment is the application of the DRE, is it?
Effectively, yeah.
And does the logic of your submission mean that if there is any benefit accruing under the policy, that it is a benefit and therefore not unfavourable treatment?
It does, and I'll come on to develop why I say that is. I've got hopefully 4 short chapters of submissions in support of those answers, and one of them, well, actually they overlap to a certain extent, but picks up exactly the point which my Lord Stevens makes.
Yeah. So, for instance, if you had a policy that you allowed, say, a a deduction from income of, say, £10 for people who are disabled, that's a benefit to them.
Correct.
But it would exclude a whole lot of other disability-related expenditures. That would still be a benefit and would still be favourable treatment.
Indeed. And that may seem
Doesn't matter
startling.
how absurd, what example one can give of a policy.
You have to identify the treatment in particular. There may be other things going on, but they're separate from what is the treatment is the first point. And there may be other events going on in a person's life, but that's not the treatment.
I mean, what one suggestion could be that the imposition of that hurdle of a £10 limit would be the unfavourable treatment.
That is possible, my lord. But again, in my respectful submission, one has to adopt a principled approach, and that's why I would suggest that Lord Carnwath's structured approach in, first of all, identifying the relevant treatment and then deciding whether it's unfavourable is an important exercise. And in my lord's example, it may be that examined through that structured approach, one can arrive at the conclusion that, in fact, while at first blush the £10 may seem to be favourable, in the proper context, it turns out to be unfavourable.
I mean, of course, in the example given, there would be a challenge open under Section 87 on the basis that the authority was fettering their discretion by having a fixed figure of £10.
There could be that argument as well, I accept that. My Lords, having answered the questions which I've posed, as I indicated, I have 4 hopefully relatively short chapters of submissions, albeit I accept that they do overlap to a certain extent. And the first chapter submissions is that disability discrimination under Section 15 is self-evidently designed to prevent unfavourable treatment. The fact that a disabled person could point to or identify possible improvement in their position does not necessarily, at least, mean that they're being treated unfavourably. In other words, I would submit it is an error to say that I, the disabled person, would be better off if you, the alleged discriminator, provided me with a greater benefit than you have thus far. And because you have not done so, you are discriminating against me. In other words, the question in my submission is not that I could be better off, but rather whether the fact that I am not is because of relevant unfavourable treatment. And in support of those submissions, I would invite the court to turn up the Swansea case, this time at paragraph 19 on page 706, where Lord Carnwath is quoting from the Court of Appeal and Lord Justice Bean. And we can see the citation at letters C through to F on page 706. And there's a discussion of some previous authority in relation to the treatment. And picking up, we can see in the first sentence a point which I think was raised in discussion this morning, that usually the treatment has been an act which disadvantages the claimant in some way. We can see in the case of Clark, the claimant was dismissed, and in the Lewisham case, Mr. Malcolm evicted. And the case of Shamoon, the Chief Inspector had part of her duties removed. Then we can see the submissions being made for Mr. Williams in the Swansea case. If I can just pick matters up halfway down that paragraph, where Lord Justice Bean says this: his pension is undoubtedly less advantageous or less favourable than that of a hypothetical comparator, suddenly disabled by a heart attack or stroke, but it is far more advantageous or favourable than it would be if he had not become permanently incapacitated from his job. The Shamoon case is not authority for saying that a disabled person has been subjected to unfavourable treatment within the meaning of Section 15, simply because he thinks he should have been treated better. And as I understand it, Lord Carnworth, in his opinion, does not disapprove that statement in the court below. Now, I dare say, being treated, seeking something more advantageous could amount to unfavourable treatment, but in the case before this court, in the case before the Supreme Court in Swansea, it did not. The second chapter of submissions, and this was a point again raised in discussion this morning in relation to Section 15, is that Section 15 does not mandate a comparison whether between disabled and non-disabled persons or between persons with different disabilities. The Section 15 questions are simply directed to identifying relevant unfavourable treatment. And in support, I should say, of that submission, I would refer first of all to Lord Justice Elias in the Griffiths case at page 517, paragraph 25. Bottom of page 517. His Lordship, I would draw attention to three matters with respect to these provisions. First, the definition of discrimination arising out of disability does not involve any comparison with a non-disabled person. It refers to unfavourable treatment, not less favourable treatment. And again, that last phrase reflects the submissions I made in the first chapter of submissions. And to return to the Swansea case, again...
So just on that, I mean, I see the force of the point being made here that a comparison between persons isn't the basis for Section 15. But might it not be said that the very notion of treatment which is unfavourable requires one to have regard to a context which, if you like, sets a baseline as to, I don't know, what would be normal, but by reference to that context one would say that's unfavourable treatment.
I dare say that's right, but one shouldn't approach Section 15 in the first instance by looking for a comparator. That comparator may, as my Lord suggests, may well provide a context, but that's not the test as to whether there has been unfavourable treatment, simply because a non-disabled person or somebody with a different disability is better off. Doesn't mean to say that you, Mr. A, have been subject to unfavourable treatment, which was really the point, as I understand it, being addressed by Lord Carnworth in the Swansea case, where again you could envisage that a different type of disability would result in a greater benefit, but that didn't mean to say that your benefit, your pension in that case, was unfavourable in consequence of your disability.
Yes, thank you.
And I was also in that connection going to, on that point, there is a case from the Employment Appeal Tribunal, accepting it's just the Employment Appeal Tribunal, clearly not authoritative for this court, but it's cited in my case. It's the case of Cowie against Scottish Fire and Rescue Service, where a similar position is adopted. I don't think I need take the court to it, but I would invite the court to consider Mrs. Justice Eadie at pages 501 through to 502 and her discussion at paragraphs 78 through to 81 as an illustration of the submissions which I've been advancing.
No. I wonder if we may have reached a convenient moment to adjourn.
Indeed, my lords, I'm quite content with that.
Very well. In that case, let's ask Mr. Daly. I know there were one or two things you wanted to look up. If we resume it, I don't think we're under any pressure for time. Are you content for us to resume at 2, or would you prefer a bit longer?
2 o'clock would be
Very well. In that case, we'll resume at 2 o'clock.